Hello everyone, today I'll be sharing another legal story with you. So what happened on 8 September 2025 is that the Supreme Court was dealing with the case of Shrija DJ and others versus Anita R. Nair and another. So while dealing with this case, basically an special leave petition was filed before the Supreme Court. Okay, so an SLP was filed before the Supreme Court challenging the anticipatory bail order. So they challenged the anticipatory bail order that was passed by the Kerala High Court, okay, before the Supreme Court through a special leave petition. Okay, while the petition was pending before the Supreme Court, the respondent slash accused, basically the respondent and accused were same person. So the respondent accused, while the petition was pending before the Supreme Court, they go to the Kerala High Court and they seek the modification of the conditions of bail. So basically they sought the modifications of conditions of the bail. Despite the matter was pending or the petition was pending before the Supreme Court, Kerala High Court modified the bail conditions and they allow the respondent accused to travel abroad. So despite the pendency of matter before the before the Supreme Court, the Kerala High Court, they modify the conditions. Okay, so Supreme Court held that since the matter since the matter or the petition challenging the anticipatory bail order is already pending before the Supreme Court, okay, and the matter is reserved before the court itself, okay, therefore any modifications in the condition of the anticipatory bail by High Court is contrary to the principles of judicial propriety and comity. So since the matter is already pending, any modifications in the condition would amount to violation of the principles of judicial propriety and comity, right? The court also said that for the proper administration of justice, right, if the order is challenged and a notice has been issued with that regard, okay, if any application is made for modification, then in that case the High Court must restrain from passing any order which have the effect of prejudicing the interest or rendering the proceedings infructuous. So the High Court must restrain from passing any order which has the effect of rendering the proceedings before the Supreme Court infructuous, because already the petition was pending before the Supreme Court. Okay, the Supreme Court cited the case of Chavi Mehrotra versus Director General Health Services 1995, and basically in this case, the Chavi Mehrotra case, it was held that the High Court should not entertain any petition. The High Court should not entertain any petition on the same issue already pending before the Supreme Court, as it is a violation of judicial propriety and discipline, right? So the Supreme Court quoted this case also. So basically this is what happened in this case. Okay, thank you so much.